since that law has been enacted, has there been any traction with regards to data protection? So take it away.
Thank you very much, Toregile, and thank you to everyone who is joining us this morning. I'm happy to see people post a cocktail. So with regards to the Zimbabwean perspective, first I want to highlight that our Cyber and Data Protection Act was initially gazetted in May 2020. So it was only after a period of over a year, almost 2 years, in December 2021, that's when it was enacted into law. And from there on, our Postal and Telecommunications Regulatory Authority, POTRAS, was appointed as the Data Protection Authority. And that's something that we were challenging right from the onset when the bill was still proposed. But that is the position of the law now, that our telecoms regulator is now our Data Protection Authority. And I know some other countries also have taken that same approach. So what has happened then since December, firstly, was that sometime in February 2022, POTRAS put out a notice. And on this notice, they were calling all data controllers and processors to submit information to POTRAS as the authority. And one thing that we have noted from that call is that so many people were not sure whether or not they are data controllers or they are processors, based on the provisions of the law. But what they defined as a controller or processor included that you should be in a position where you collect personally identifying information for at least 30 people. So that is what they put out in their notice in February this year. And as MISA, we then had a breakfast meeting with POTRAS just to find out how far they are in terms of implementation of the law. And what has happened to this stage is that we understand that POTRAS has been engaging with other data protection authorities in the region. And also that from that notice, there were thousands of notices that were given to POTRAS. Thousands of people in the country, responded. 30 is a very minimal number. Even us as NGOs, we host meetings and we collect personal identifying information for 30 people and over and above. So there was overwhelming response, and from what we understand, POTRAS felt that they are not yet in a position to be able to fully handle this role, particularly based on the amount of feedback that they got from the notice. But also that they started categorizing the feedback, categorizing people into sectors. So as part of the plans, the intention is that they're going to be engaging sectors, for example, retail, banking, government departments. But also maybe just to zero in on the gaps. In terms of our law, the law presents a framework for data protection, but there are so many other areas that the Data Protection Authority is supposed to provide guidelines for. For example, the Data Protection Authority is supposed to advise on the qualifications and functions of data protection officers, because one of the requirements is that every processor and every controller should appoint a data protection officer. So from their February notice, one of the requirements was that you should have ordinary level. I'm not sure how you qualify it in your other jurisdictions, but that's like secondary school education. Whether or not that is a good qualification for data protection, also that should be a minimum requirement, is subject to conversation, but that is one of the things that they highlighted. But so far we have so many gaps, like I mentioned, one being that issue of the functions and qualifications of data protection officers. Another also being that they're supposed to give guidelines in terms of minimum requirements for information security. So data processors and controllers are supposed to have standards for information security, because they're collecting data, they're processing it, so they need to put in place mechanisms for the security of that data. So they are supposed to put also guidelines that speak to what the minimum requirements should look like. Another area also that is still lacking is an area regarding notice of a security breach. So in terms of the law that we have, there's a requirement that in the event of a security breach, within 24 hours, the controller or the processor should notify the authority, but they do not provide information in terms of what the notice should look like. If there's been a security breach and you're giving a notice to the authority, what kind of information should you give? Should that speak to the remedy? Should that speak to the interventions that you are putting in place to address that security breach? There's still a gap there, and they are yet to address that. But also there's a provision that speaks to cross-border transfers. and it's also the responsibility of the authority to put guidelines that speak to circumstances where cross-border transfer is not going to be permitted. So all those areas are still not clarified. So as a result, there are still gaps. There's not been much enforcement as far as the provisions relating to data protection and privacy are concerned. But I understand it's still work in progress, also because the authority itself is not yet fully capacitated. Just sometime, I think in June, they were calling for applications for people to apply for roles under their Data Protection Authority department. So that means they're still lacking even in terms of staff. So as a result, there's still a gap even in terms of the implementation, because the authority responsible for implementing the law is yet fully capacitated human resource-wise. So that's the status, and those are the gaps at the moment.
Thank you so much for unpacking where we are as a country in Zimbabwe, at least. And one of the key things you've highlighted is that there's need for more things to be done with regards to making sure that the Data Protection Authority in Zimbabwe is able to fully implement the provisions of the Act itself. And I think one critical thought or one critical question is what should ideally be the case with data protection authorities? Should they should that function be vested in an independent institution, or should it be vested in an already existing state agent who has other functions to discharge? And clearly from what you are saying, Fortras is saddled with many other roles, and as such, they are still battling to be able to fully discharge what is required in terms of the new law in Zimbabwe. And I think that is definitely a very serious gap that we're noting. And I hope at some point, Adrian, will be able to unpack what should be ideal in the situation with the function of data protection authorities. But before I ask you to step in there, I'll ask maybe for Glory, just show us a sneak peek of what it is like for data protection in Tanzania. Even now, when we are talking about a data protection law that is in the offing, that is not yet ready, what is the case? Because data is still being mined every day.
Good morning, everyone. My name is Glory. I work with Jamii Forums. It's a CSO that advocates and promotes civil and digital rights. So in the case of my country, as it is right now, just last week, the government bill was tabled at the parliament. Before, Tanzania had two bills which never made to the parliament due to the draconians that were in those bills. We at Jamii Forums decided to draft our own bill and presented it to the government because it was taking so long for the government to work on a data protection law. So we decided, why not do it ourselves and give it to them, see what they can do with it. So we presented our bill on May this year, and we have been in meetings with the top officials discussing our bill and then see what they could use out of it. And just a few weeks ago, they decided to start the processes of enacting their own bill, and it was tabled just last week. And the question that has been on the, maybe not the question, but the biggest issue was having an independent commission as data custodians of the data protection law. And we had a meeting with the Minister for Information, and he was saying, why should we have an independent commission? This could be done, this can be under ours, and it's a subject that we're still discussing to date. We have seen the bill that was presented by the government. Unfortunately, it is not clear on the independent commission. Is it going to be an independent one or not? So that's where we are trying to draw a line to see what's going to happen next.
Thank you so much for unpacking that. But I'm still curious on what happens to people's data and how people are treated. I know as Jamie Forum, you probably have insights to what happens to people when they, is people's personal data secure or safe without this framework?
Right now, as it is at the moment, we cannot say it's so safe. For example, we had our census just a few months ago, and we kept on asking people from the government, where are our data going? What happens to our data? What if there is a breach? Who is going to be responsible? Because the people who conducted the census were not government officials. They just took people and from the streets, and they were the ones who conducted the whole census process. So we're concerned about our data, and the government is not saying anything currently. We do hope that the bill, the law, will have something to do with our data, but that's something to do in the future. Right now, our data are not as safe as we would wish them to be.
Thank you so much, and great work that Jamie Forum is doing as well, pushing for this. And I suppose you can seriously claim a stake in, putting this bill in the oven so that it cooks. I think you've taken strides in that direction. So great work there, and hopefully before the year ends, like I said earlier, we'll be talking about 34 data protection laws on the continent, and then continue with advocacy for the remaining countries to enact these laws. Right. So Adrian, I think I kind of preempted where I'm going next, I think, and I'd like you to just unpack what should be an ideal data protection authority. I mean, should it be something, I know governments have different excuses for why they would not want to do this. Resources is always one of them. But definitely looking at best practices and standards, what do you think is ideal in this situation?
Thank you very much. Though you have said what I'm supposed to say. But nevertheless, you know that one of the leading benchmarking examples for data protection and privacy is the General Data Protection Regulation of Europe. And as someone stated yesterday, that most of the countries have been trying to emulate or pick what is in the General Data Protection Regulation and apply it in the national legislation. However, if you have looked at the General Data Protection Regulation in comparison to the national laws or instruments that have been enacted to provide for data protection and privacy, you'll discover that there are too many shortfalls in the national initiatives or in the national laws that are there. Of course, the African Union Convention on Cybersecurity and Personal Data also tries to emulate as much as possible what is in the General Data Protection Regulation. Unfortunately, this Malabo Convention, when it was adopted in 2014, already some countries had data protection laws, and others came in, for example, like Uganda, like Kenya, like Zambia. These countries enacted laws later, but still they fall short of what is specified in the Malabo Convention. But back to what she asked me, ideally, a proper data protection authority is one which is supposed to be independent with a level of autonomy, not really subject to external influence or external direction as to what they should actually do. The unfortunate bit that is happening, I think except for one of the countries I've met is Ghana, where they established an independent authority. But for most of the countries, they're trying to ride on the backs of like the POTRAS, the Postal and Telecommunications Regulatory Authority of Zimbabwe, Uganda Communications Commission, and then Kenya, and then Zambia here. All of them are struggling to just establish either what they call data protection offices or data protection commissions to manage data, but they are fully dependent on already existing institutions which have been highly doubted in the past as to whether they can actually competently protect data of the individual, that's one. Two, if they are really not subject to direction or directive from external influence, especially the executive, as they have always done, because the executive appoints the people who are usually in charge of these authorities. And from the past, the practices over the sectors, they regulate based on what they are being told to do. Say, do this, and they will direct the institutions and do this. So it is highly in doubt that these offices and commissions can actually guarantee data protection and privacy. But ideally, as they say, a data protection authority, which we are quite certain could guarantee data protection and privacy, is one which is independent, financially self-reliant, with its own budget, as she mentioned about, where it can manage its own resources, and with individuals who have been appointed to the capacity of being in charge of data of individuals without unnecessarily being subjected to direction from external forces or from external authorities to say, this is what you should do, this is what you should do, this is what you should do. Maybe before I conclude, I want to, in Uganda, when they were trying to enact the Access to Information Act of 2005, civil society took an initiative and presented the Access to Information Bill as a private member's bill through a private member of parliament. When government saw that, they were not amused, so they decided to present their own bill. And the bill they presented was actually, when you read the access to it lacks a lot of what should have actually been in a good law. And we have been pushing for and calling for amendments which have not. So when I saw the draft bill, I think it was shared from Jamii Forums. We actually tried to input, but me, I really put with reluctance, knowing this is already a lost battle, because we're trying to deal with data protection and privacy, which is something of big interest to the government. And indeed, as she said, that they decided to put it aside, and now they have drafted their own. And when you go and check, you'll discover that whatever they are presented would be having too many shortfalls in comparison to, because the draft bill by Jamii Forums tried to, as much as possible, pick what, for example, a comprehensive data protection law should look like, with the authorities, with the independence and all that, and all the rights elaborated, the principles, what the duties and responsibilities of the other parties are supposed to do. But ideally, in a true setting, is that those authorities should be such that, given anywhere, they have that authority even to listen to complaints from people, to respect the rights of the data subject, to ensure that all the principles of data protection are adhered to and followed to the dot, as opposed to where they are simply doing what they're being told to do. Do this, and do this. And that's the unfortunate bit about Africa and most of the countries that are active. So there's a lot of work for us to do, but I don't know how we shall do it when we still have those governments that keep directing us.
Thank you so much, Adrian. And yeah, the journey for advocacy, just you don't quit. You keep the pressure going. And I feel like for data protection, it's more of a chase for quantity than it is a chase for quality. Comprehensive legislation that addresses data protection, and particularly in Africa, we've been counting, like we're celebrating, we've got 33 countries that have data protection laws. But definitely, there's room for digital rights practitioners to assess to what extent these data protection laws are actually being implemented. And I think from the conversation we've been hearing here, clearly we have data protection laws that come into force, yet the architecture that is meant to make sure that that law is implemented is very lacking. You find that now, like Potras is still trying to hire and configure a data protection unit under the house or rather the frame of Potras. And that is a major gap that we're seeing. So my question now is that what is happening even at country level with regards to advocacy to ensure that whatever law we have just doesn't remain a law. It becomes something that is meaningful for data governance, something that is meaningful to ensure that people's personal data is secure. So I'll start with you, Untitled. What's being done and by who?
Yeah, so this is a very interesting question. And I mean, when Adrian was speaking and was saying, oh, this is a lost battle, I laughed because I know it's not a lost battle. It's impact that, government now feels the need to push their own bill because they've seen that, the CSO sector has taken initiative to develop a model law. So I think it's something that always works. And like you said, to regulate that in the region, we have countries that have been coming up with some of these laws. So in terms of advocacy, firstly, the stance that has been taken by Yami Forums is quite interesting as far as advocacy is concerned, to develop a model framework. So that's the same framework that they can use, when the law is brought to the public, because that is also the strategy that we took as MISA, that you develop a framework or a standard or a model which you then present to the policymaker, say this is our model, this is how we think the law should look like. We already have the Malabo Convention, as you mentioned, which is also equally a good standard. So it's always important to emphasize on the standards that we already have, not only in the region, but also even frameworks that we can develop on our own, particularly civil society. But from there on, utilize knowledge products as part of advocacy. One thing that I've seen that is lacking, particularly in advocacy, is that when CSOs are leading conversations around data protection and privacy, it seems like a CSO thing. We need to create citizen agency because we are representing the people. So the people need to understand why data protection and data privacy matters to them. How is it an issue of importance to them as individual people, as ordinary citizens, as internet users? The moment we create that citizen agency, that will also be important in terms of addressing, pushback from the government. When you've presented certain standards and governments are not willing to adopt those standards, it's always a good strategy to utilize the people's position, particularly also because of the online space and how it has influenced online activism. I feel that's one angle that we can use as far as our advocacy is concerned. But also, these laws are created normally, for example, in the Zimbabwean perspective, the minister drafts the principles and then they are sent to the Attorney General's office. The Attorney General's office is made up of legal drafters. They are not exactly experts in data protection privacy, they're legal drafters, which is why also in the region you've seen some sort of copy and paste in the laws, because we're just looking at what others are doing and seeing what we can take and maybe what we want to leave, depending on the context, right? From there on, the law is then brought to the Parliamentary Portfolio Committee for public hearings. They are going to public hearings and asking people to contribute to a law when people don't even know. Normally people are concerned about bread and butter issues. If you say we are coming with a data protection law, people look at you like, what is that? And where do we come in? So that citizen agents will also come in at the stage of public hearings. And sometimes you find that you go to a public hearing and no one has meaningful input to contribute to that process. But from the Parliament's perspective or the Parliamentary Portfolio's perspective, a public hearing has already been done, the public has already been consulted. You move on from there, you go to Parliament. Parliamentarians are not appointed on merit. They are appointed political party lines, sometimes they're independent, but still they are not appointed on the basis of on merits. But these are the same people that we expect to debate meaningfully on a data protection framework. So advocates will still come in there in terms of capacitating them, and I would equally advocate for identifying agents of change. Because when you're engaging with parliamentarians, it's not every one of them who is interested in the agenda or in the issues. It's always important to identify within the different stakeholders who is better placed to champion your agenda, to champion the specific issue. So from an advocacy perspective, those are some of the things that we have seen happening, but also those are some of the things that we can also think about and consider as the other countries like Tanzania start discussing having a data protection framework.
Thank you for highlighting that, people are not aware. And I've been in spaces where I've heard governments say, you people, you're pushing this agenda, but you're saying people should have, this as a right. What's the fuss for data protection? And of course, the response from our end has been, okay, we are concerned about freedom of expression, access to information, privacy, etc. And yet the government will tell you, the people themselves, the victims that you are saying are victims, they don't care about these rights. And we are saying, but you as the government have not taken the step to capacitate the public. But ideally, civil society must seize the moment, seize the space, do campaigns, engage. And I'm quite curious, where is the human rights, the National Human Rights Institution, Zimbabwe Human Rights Commission? Are they actively involved in this conversation as well?
Yeah, that's a very good question. For example, in Zimbabwe, our commissions are Chapter 12 institutions established through the Constitution. But we have noted, these commissions function on budgets allocated by the government. So it takes me back to what Edwin was saying, that these commissions do not have the independence that we would expect them to have. So sometimes, in some of these conversations, they have to be politically correct in the conversations. Like, for example, just digressing a bit, we have the recent resolution on protection of women against digital violence. But I'll tell you, our Zimbabwean Gender Commission is not commented on that, resolution. Why? Because they also wait for direction. They also wait for the ship to be steered by other actors apart from them. They are not taking an active role in these conversations. So there's definitely an opportunity for the commissions to be brought on board. So that multi-stakeholder approach that I spoke about earlier, and when we're having these conversations, we also need to bring in our national human rights institutions into the conversations. More often than not, you find, when we are engaging CSOs, you look at the CSOs, you look at the media, but you also forget that, we have commissions that are in place that are also championing or supposed to be championing the promotion of human rights. So it's always important to include them in the conversation, but also to ensure that, they bring out certain policy positions as the commission. So for example, even our POTRAS, being the Data Protection Authority, the law even says POTRAS is supposed to issue opinions on certain data protection issues that will be emerging in the country. So it's always important even for the human rights institutions to give their own position or their own opinion on things that will be happening in our landscape as far as data protection is concerned. But we have seen that they're actually lacking. It could be an issue also of capacity, that they're also not fully capacitated in the space, and they're not fully aware of the issues. So that's where also as civil society we can come in as a strategic partner, to start engaging them, to start sharing information with them, and also to start giving them ideas in terms of next steps, or in terms of the strategic or the roadmap that they can take as national human rights institutions.
Thank you so much for highlighting that. I think definitely they have a critical role. And let's hear in Tanzania what the situation is. I know definitely that there's no law at this point, but do you have a national human rights institution that can be able to, that you can leverage and be able to push, forward this concern? And also just touch as well on what other, civil society organizations have been doing, or what other, advocacy initiatives that have been running that you could be aware of.
Honestly, when it comes to human rights organizations, we haven't involved them much, and they haven't shown interest in the subject of data protection. But as Yami Forums, we decided to take our own initiatives by first raising awareness on the importance of data protection, because when we started, we realized that most people were not aware on the importance of having a data protection law. They were not even aware of what is data protection. Everyone we tried to engage with, it was a new subject to them. And so multiple approaches were being applied by us. First, engaging state actors, because these are the policy makers, they are the policy changers and everything. So we decided to first sit with them, speak to them on the importance of having a data protection law. Even themselves had no idea of what is happening. And some of them were victims of data protection leaks from previous. So right now what we're doing is engage even religious leaders, because they reach as many people as they can in their own capacities. We're trying to also engage other CSOs and MNOs, other private sectors, to also not only build awareness, but use them as our champions and to be our voices out there. And we have also tried to build capacity to the members of parliament. Even them had no idea of what's happening or what needs to be done. We start with 120 parliament members who had no clue of the importance of having this law in the country. And theirs has been tabled, but we decided, you know what, let's first build capacity for these people so that when it's tabled and when the discussions start in the parliament, they are aware of what's happening, what needs to be done, the importance of having an independent commission. So we start with them in the mainland and in Zanzibar, the island, because you have to do this both ways. You cannot just do it in the mainland and leave the Zanzibar people. So that's what we're trying to do right now. But also we have strategic partners that we're involving with to also help us communicate to the government, because if we do it as Jamii Forums has been labeled as an anti-government from the start. So it's a bit difficult to engage with them at some point. So we use other strategic partners, ask them to engage with the government as well to see what they can do to support us and ensure that we have a very well legal framework when it comes to data protection and privacy.
Kudos to you for leveraging your networks, and you see how it goes. I think anyone who criticizes government is labeled, in the Zimbabwean context, regime change agents. But well done for continuing to do the work that you're doing. Yeah, Edwin, I'm going to bring the biggest elephant in the room, which is the Malabo Convention and the reasons for low ratifications at African level. So we have this homegrown solution to African problems on data protection, which is the Malabo Convention. But I keep hearing, even in platforms like this, that data protection laws have, the spirit of the GDPR. But I'm trying to locate our own Malabo Convention in the context of data protection on the continent. And what are your views in terms of why there is that low ratification? Because now we want the law to come into effect, the treaty to be enforced, but we've got low traction across the continent, despite having these data protection laws that are really not ideal.
Thank you very much. The fate of the Malabo Convention is not new on the African continent, as you may all know. For example, we have the African Court on Human and People's Rights. And you know what has been happening? Some countries had ratified and even deposited instruments. For example, I'll use the example of Tanzania. The debate was, we want our own African court. We don't want the international criminal court. It's targeting the Africans. So when the court came in, and it was, I think it had issued very progressive decisions, especially against Tanzania. So Tanzania decides to withdraw, says, no. We are now withdrawing our being subject to the jurisdiction of this court. But one of the things that has been the lead cause of that is, maybe from the start, is that when you read the Malabo Convention, you'll discover that it tries to iron out some of these controversial issues that we are facing nationally. That's number one. Number two is that the governments on the African continent, almost all of them, except maybe for a few that we need to find, are more interested, for example, when you talk about collection of personal data and the storage and processing of personal data. They are more interested in finding ways of how they can actually access the data and use it to their interest of what they want to use it for. Because when you read the laws, one of the major challenges you'll find in the laws, the national acts across the continent, you'll discover they have provisions which specifically, this one will say, okay, this is personal data, it should be protected. This is personally sensitive data, which should be protected in such and such a way. However, data provided for in clause this, the protection may be waived in cases of the following. Then they list different examples: national security, they list public interest, they list public health, then they talk about national planning, and so on and so forth. So ideally, why it is not properly highly implemented, those are some of the reasons. Then the other reason, it takes us back to what we call in international law as sovereignty. So part of it, when they read some of the provisions, they think, I think this is imposing self-imposition of these provisions onto specific countries, because we are sovereign countries, we can make decisions on our own, so we do not have to keep following. So, and that has been a major challenge in as far as the adoption and implementation of regional and international laws in our different or various countries is concerned. So countries are more concerned with, they do not interfere in our national matters. We can handle them if we want. So we do not want your law. They agree and enact a law, and then after they decide not to implement it. So perhaps because we've even been making calls severally on countries to sign and ratify the Malabo Convention. But as you all said, I think up now about only 13 ratifications out of 55 countries on the continent. So some of them have signed, but they have not ratified. So, and yet still we do not have all countries having to say that they have enacted data protection and privacy laws. And yet still this instrument aimed to harmonize how data protection and cyber security should be considered by the different countries, as well as harmonizing the information society across the countries to promote really a safe cyberspace for all peoples on the continent. So in brief, those are the reasons I could say, but mainly talk around sovereignty and particularly government interest in accessing and using data of individuals, especially those specific individuals I talked about yesterday in some sessions. Human rights defenders, political activists, government dissidents and critics. Their information is so much needed. So how then can you say we want to guarantee robust protection of their personal data? We have to find ways of easily getting it so that we can track them down and deal with them to pump sense, which sensing reports in their head so they can know who they are dealing with. Yeah.
Thanks, Adrian. I think our work is cut out for us. We have work towards making sure our advocacy work towards, data protection laws being enacted in the countries. Without those laws, we've got work as well, where we have data protection laws to chase after the actual implementation, and also the function of the data protection authorities. We've also got work again to try and run campaigns towards pushing for the ratification of this Malabo Convention. And I think we just need a few more. I think it should be one, if I'm actually not mistaken, one or two countries that needs to just sign and deposit this ratification. I mean this acknowledgement that they are ratifying the Malabo Convention. So a lot of work there for digital rights practitioners, and thanks a lot for highlighting that. But we've got wonderful people here. I think you've got your own experiences within your context, or you have questions for these wonderful panelists. I'll open it up now to everyone here to just share your insights, your thoughts around data protection trends and advocacy in Africa. Who wants to break the ice? Tara, thank you.
Thank you all for your wonderful insights. Our sense of the Malabo Convention is that civil society is quite divided on whether or not advocacy efforts should push for the ratification of it. I know we only need 2 more countries to ratify it before it comes into force, but I know some people are of the view that we should rather turn our efforts to instruments that respond better to data protection and take account of new technologies like artificial intelligence. So I just want to get your thoughts on that debate and whether you think it's worth pushing for or if we should turn our attention to something else.
The debate and the divided voice of civil society on data protection, on the Malabo Convention. Right, I'll take another question and then I'll ask you to respond.
Yeah, thanks to the panelists for that exciting conversation. 3 questions. Given the challenges that you have mentioned, that even where you have, what is it called? Protests? Yeah. And others that maybe have not been mentioned. What sort of, looking at models that would kind of address some of the challenges, they are not as independent as would have wanted, there's a risk of political influence over the decision making around those mechanisms. Ideally, what accountability measures or mechanisms would you recommend, you know? So the kind of oversight, ideally, that would help to check how they are handling their mandates and functions. And then secondly, around the public awareness, I see that you've mentioned also in Tanzania and SIM, you've mentioned also that it's a big challenge, that even when you have frameworks or draft laws, the public is invited, they don't understand, and they can't engage meaningfully. But I didn't hear any of you mentioning how you're utilizing the media as sort of a capacity building, you know, actor around these issues. Have you seen that they play a particular role that could complement what you're doing with all the other stakeholders? Because I'm thinking they have such a big platform. And then thirdly, on Tanzania, ICNL also had input on the model bill that Jamii Forum presented. And now that the government has given an alternative, and also what Adrian said, that oftentimes these alternatives seem to be they are not as robust as the model that you would have. Have you done any comparisons to see whether the Tanzanian situation, the bill that the government has presented, is actually fundamentally different from what areas, if so, have actually been missing in that particular bill that the government is proposing compared to the one that you did?
All right, I'll come back to you, Wakesho, in case the panelists, I think one of the questions will fall within the cracks. The first question is really around civil society's, divergent views or opinions around the Malabo Convention. I don't know who wants to tackle this one. Perhaps Edwin, you raised the Malabo Convention. Do you have any thoughts on this?
Yeah, I can give some thoughts, of course. Well, it's not. One of the things I can say is that despite the various challenges some of these instruments interface, especially in the advent of implementation and so on, at least it's like when we decide to say now we want to evaluate the Universal Periodic Review, for example. And we say, yes, they make recommendations which are really not binding, but somewhere the states ensure that at least they comply, because when others are looking at your human rights record and it's not okay, then you know there's a problem, even in your relation with other countries. So in terms of that, I think we cannot say it's a totally lost battle. As civil society, we can keep pushing and engaging, especially the states, to measure to the standard of the instruments, like the Malabo Convention, for example. So ideally, our measure or our results may not be seen from a perspective where you say, okay, the state has done this and this and this, but in our constant work, for example, we can, the moment we realize the ratification and it comes into force, so we know that at least we can measure the state against that, even if they have not yet signed and ratified. But when we are making use, for example, of the regional mechanism, like before the African Commission on Human and People's Rights, then we can bring it to the attention of the commissioner and the entire commission, say this is what is happening, and of course the commission can make the appropriate recommendations to a particular state. So ideally, civil society cannot win or give up on that, but as they say, the battle is to keep pushing, because at some point in time, at least the state will be held accountable based on that, even if they have not integrated, even if they choose not to disrespect, but since they are members of the African Union, then ideally should expect that they should at least minimally to a particular standard adhere to the principles, the rights, and all those cybersecurity standards that are specified to ensure that the information society again is harmonized as the convention puts it, and that everyone on the continent is actually secure in their transactions, commerce, when on. Yeah, that's what we can say.
Thank you so much for that response, and I'll just also highlight the importance of treaties and the fact that they bring in core obligations of states, and I think it's a low-hanging fruit we can leverage, and even in as much as it still has other areas that it has not covered, like under AI and things like that, a developing area on the continent. The African Commission is finalizing a study at this point on AI. So to even talk about an AI treaty at this point, they are still trying to establish, okay, what is this creature called AI? So you find that what we have currently is the Malabo Convention, and this is, well, from this particular civil society, I think it's a very progressive thing to push and drive for ratification of the Malabo Convention in as far as it addresses data protection, possibly not in as far as it covers sufficiently safeguards for AI use and application. So yeah, over to you, and then we'll go to Tanzania, but let's hear about these efforts and the issue of public awareness and the media, etc., and the communication that have come through from the front.
Yeah, thank you very much to Regila. I just want to come back also to affirm the position that has been shared already from both April and yourself about the Malabo Convention. That, you know, as a continent, we are still playing catch up as far as technology is concerned, as far as regulatory frameworks relating to technology are concerned. So I still think it's important to have some form of regional cooperation and collaboration, which can be through the Malabo Convention as far as cybercrime and cybersecurity and data protection is concerned. Because, you know, we need to also sometimes think about these issues from the perspective of governments and speak government language. So you find as a continent there have been so many conversations around the Africa Free Trade Continental Agreement, for example. So, and you know, when we speak about that, we also think about, you know, cross-border transfers of data. You know, there's the digital economy. There's so many issues around data protection and privacy that come in outside, you know, national jurisdictions. So it's always important to think about regional cooperation from that perspective, that if we are thinking about, you know, taking up these continental interventions, we need to have supporting instruments also that present a continental position. So I still think it's important to leverage on the Malabo Convention as a continental document that speaks to, you know, data protection and privacy, and which other jurisdictions can also then, you know, utilize as a standard for their own national or domestic laws. But to speak about the accountability measures, there's so many aspects that we can push for or champion, some which also we're calling for as far as, you know, the data protection authorities are concerned. One of them being an issue of appointment. In Zimbabwe, it's an open secret that you know, the Director General of Potras was a person who was formerly in intelligence. That raises suspicion and concern from ordinary people. That, you know, Potras is the telecoms regulator. They house the database for SIM card registration. They also house the system for telecommunications traffic monitoring system, and also they're the data protection authority. So the people that are steering the ship, or the leadership behind that authority, is obviously an issue that would be of importance. So the issue of appointment, who is responsible for appointing the board, for example. So the issue of public nominations, public interviews will always come into play as one step or as one mechanism to think about. But also even reporting mechanisms. So in their role as a data protection authority, do they have an obligation to report to Parliament, for example? The parliamentary structure is there as representatives of the people. Do they report to Parliament? Because I think from our perspective, from our jurisdiction, Parliament reports to the Minister of ICT, but should there not be an obligation for them to report to Parliament, for example? So those are the other accountability mechanisms that we can also think about. But generally also, you know, because also when you think about the role of the executive in influencing the work of the authority, so the issue of appointments, like I said, but also that the minister can issue regulations in that Data Protection Act, it says the minister can issue regulations. The authority can also undertake certain work after consultation with the minister. The minister is a member of the executive. So that is an issue also that would be of concern to say, so what is the minister's role? To whom is the minister getting certain directives from, So when you think about also those issues in terms of how the executive can influence the functions of the authority, that would be a challenge. So the issue of autonomy would still come into play to say, to what extent does the executive interfere with the function? So putting safeguards in terms of, executive interference is another mechanism that we can think of. But to say, yes, the media plays a very critical role. That time when I spoke of a multi-stakeholder approach, not only was I thinking of civil society and the state, but also academia and the media and the private sector also, because the issues of data protection and privacy impact all these sectors. So that would also be very important. Yes, definitely the media is very key, not only in pushing the narrative, for example, of why we should also be associated with the Malabo Convention, but also generally why data protection frameworks are important, why it is important, for example, even for investment. So it's always important to speak the language of government, particularly for the media, especially when they're trying to push an agenda. But also the media is there. Even in Zimbabwe, they have a constitutional role to disseminate information. So that citizen agency and awareness that I was speaking of earlier, the media has a capacity to unpack these issues in a language and a format that is understood, by citizens. And also when we think of media, we think of various players in that industry. We don't only think of journalists that, publish stories. We have cartoonists that properly package information in a very creative way and in a very simple way that appeals to their audience. I think even here at FIF Africa, there were sessions that spoke to, creative art as a form of advocacy. So when you think about the media, we can also think about those different forms, of the media and of, communication as a way of packaging information around the importance of the frameworks, the importance of the convention, why the frameworks should be substantive and should have clear safeguards for data protection and privacy. So I just want to agree with you that indeed the media plays a very key role.
Thank you so much, for raising that. And definitely we need a lot of accountability. We need the checks on the executive so that the executive refrains from violating people's rights. Let's hear from East Africa / Southern Africa. I don't know. Yeah.
So we at JB Forums understand the importance of using the media as a means to create a public awareness, and we've been doing some trainings to journalists so that they understand the language to use when it comes to data protection and privacy. First of all, build capacity for them, and then at least have them aware of what language to use out there so that the public is aware of what is happening. And apart from that, we've been engaging with local media houses, like more than 10 media houses. We try to engage them from the start of this project of data protection. And so we understand the critical part the media plays when it comes to public awareness. And we are using the media is one of the biggest means to get the message out there. You asked about the difference between the model bill that JB Forums created and the government bill. We have had a sneak peek of the government bill, and again, the issue for independent commission, like I said, is still like we did not understand what it entails. In our bill, we made it very clear that this should be an independent commission. The director of the general director should be appointed by the parliament. So a few weeks before the bill was tabled in the parliament, we had a meeting with the minister of ICT, and he wanted us to take him through the bill that JB Forums drafted. And when it came to the appointments of the DG and the independent commission, he had two concerns. His first concern was, if we start doing appointments like this, like you're suggesting, use the parliament to elect the DG, then every other appointment that will be coming through from in other organizations, in other bodies, will have to follow the same procedures, and we don't want that. And right now in Tanzania, there is an issue of having an independent commission for election. And he said, if we have an independent commission for this, then it means we'll have to have an independent commission for the election board. So that's where the challenges are. They're trying to avoid all that. So still in their bill, we're missing those things, and we're missing them simply because they're afraid of the trend that this will set when it comes to independent commissions, when it comes to government appointment officials. So that's the main difference we've seen from the bill. We just had a sneak peek. We'll keep on reading it, and we'll share with the SNL because you are our strategic partners in this, and so you see for yourself what it entails.
Thank you so much for highlighting that, and thanks as well for collaborating and with others, especially I see now for your support in this. And Adrian, I don't know if you want to weigh in on some of these questions that were raised as well by Florence in the Ugandan context in terms of what is happening, raising awareness, etc., accountability.
All right, from a Ugandan perspective, of course, the Data Protection and Privacy Act was enacted in 2019, and we tried to intervene at that level. We made analysis. Of course, the Ugandan bill, I think, straight from around 2014, and only to be enacted in 2019. So after all that time, there had been engagements here and there from different partners. We did analysis, submitted, and then another version of the bill came out. We did analysis and submitted. And of course, in Uganda, we've been working as a civil society sector, not only CPESA, but with other civil society organizations. And incidentally, of late, Ugandans are quite active. Of late, we even get comments from law firms, from even individuals going before Parliament to present their concerns about the bill, like for example the computer misuse bill that was enacted recently. But as they've also stated, there have been similar challenges, especially on the conceptualization and understanding of digital rights and freedoms, as well as data protection and privacy. The issues of parliamentarians and not understanding is cuts across, because these are emerging because of evolution and advancement of technology. Again, the other challenge we have seen emerges from the judicial arm of government, where, for example, if you're to present a case that has issues of data protection and privacy, quite interesting. You do not have judges who understand these issues. And judges, as you know, across the continent, they don't want to be taught, they come from the group they call learned friends. So for them, they know everything. So they don't want to be taught unless you say we're going to do a colloquium or something like that, so that they get to know actually what is transpiring. But one of the major concerns as well, you said, was about data protection office or an independent data protection commission. So what it said to put it under the National Information and Technology Authority, which was established to manage issues of technology, e-governance, and so on. So it was placed under that to avoid issues of probably financial implications, because an independent commission would come in with the need for more money. But ideally, as I've mentioned earlier, there were those concerns of independency, autonomy, and practices that had happened in Uganda about directives and how those directives impact on independence of agencies. But otherwise, civil society is still alert. We continue doing work that relates to data protection and privacy, as well as digital rights. Again, I was about to interject and say we need to have a copy of, I remember it's in the public domain, the one of Tanzania, because we have to do an analysis probably together with Jamii Forums, then we can forward upfront comments to the Parliament, so they try to look at them and consider for potential changes. So ideally, and we also continue to build capacity of journalists, human rights defenders, entities to ensure that they are compliant with the Data Protection and Privacy Act. And as of now, I think December last year was the deadline for data collectors, controllers and processors to register with the Data Protection Office to ensure that individuals' data that is in their possession. And of course, those include quite a number of agencies, including hotels where people go, including CSOs. For as long as you deal with public information, you register people's names and what. So we have been trying to raise that concern such that people are aware and comply with all the data protection and privacy requirements as provided for by the law. Yeah, so in brief, that's what has been happening on the landscape. In Uganda,
away from ourselves, away from government. And usually when we say government, we look at
even as we were talking yesterday that this Data Protection and Privacy Act you're fighting for, and Zimbabwe, Zambia, Ghana, you should also be prepared that there are other laws that enable data protection, as it is already being done, I should say. That data is being mined, and also that this data which has been collected can be used by the states to their own interests, to look for those they want. And also the aspect you raise of transferability of data from one jurisdiction to another. There's also a concern that we have observed that, yes, that could be actually an easier enabler for a government from where data is coming from to get that data from another country where it's going. Because at that level, you as an individual, you may have no way of engaging, but you can say, ask the other country and say, give us data on this particular individual or what they're doing, and they'll easily get it. So that transferability aspect is in itself a danger because it facilitates easy government access to your data from another government without even you noticing or anything. So that is it.
Thank you so much, Adrian. There is definitely a lot of work, as the likelihood of data being under siege is very high, without being dramatic. Wakesho, I think you had a question there for us. I don't know who else. I'll just take the last round before we land the plane.
Thank you. That has been a very informative session. My name is Wakesho Kimilo from Internews. And yes, that has been very informative, and it's really happy to listen to this conversation. Of course, I come biased because we work together, and I'm actually, I can closely see the good work that all of you have been able to achieve in terms of advocacy around data protection. And probably maybe I have a comment on the question. So maybe the first comment also, even in light of the wonderful work that we see advocacy doing in Tanzania, we actually recently had a campaign around data protection, and the organization that did that is not here today, but I know they partnered with including Jamii Forums, and the data protection bill was actually read for the first time in Parliament a couple of weeks ago, and that's actually maybe one of the successes that I think we can actually proudly say as that comes as a result of key continued advocacy efforts. That's one. Then the other thing, and I think this also session was aptly named, data protection trends and advocacy in Africa. And one of the things that I've been trying to just think through as we were having this conversation is the available spaces for CSO engagement that we have regionally. And one of the things that comes to mind one is the Pan-African Parliament. And when you look at the protocol of the Pan-African Parliament, it actually says that it was specifically, the Pan-African Parliament was specifically established so that we as Africans have a place to engage and to air out our issues. And so, that is one key creative place that we can take advantage of, right? And again, on the Pan-African Parliament, it has particular caucuses, and currently there are only 2 thematic caucuses on women and youth. And I'm seeing, is that one of the areas that we find also might be particularly useful for us to plug some of these issues. The other thing also is the fact that we can also get, as CSOs, we can also get to petition the Pan-African Parliament, bring this to them, and also trigger motions because they play a very critical role and they have access to other organs of the African Union. And we as CSOs can come together and specifically, bring our issues to them and also give them particular questions that they can ask to other political and judicial organs of the African Union. That's one, the Pan-African Parliament. The other thing also is the AU, the statutory meetings of both the ordinary sessions of the African Union Assembly as well as the judicial, human rights and legal organs. Are those spaces that we're keen, or are we seeing people taking part in this? The other thing also is NGOs with observer status. I'd be curious to know whether maybe in our levels of engagement we found out whether any of these NGOs with observer status are actually also dealing with some of these issues so that we can then tap into them for them to raise issues and to advocate for on our behalf. The other thing also is the Economic and Social Cultural Council, which was specifically created so that CSOs again can engage with the African Union. And it actually currently is comprised of 150 CSOs. And again, I think this is a very good opportunity also for us to plug in and forward some of these issues. And finally, also the African Governance on Architecture platform, again, very key instrument, key platform, that we can use for advocacy. So I guess that's partly comments and also partly questions as to whether we are seeing digital rights, data protection issues being taken up in these very key spaces for engagement. Thank you.
Thank you so much. Yes?
Thank you so much. It was really very informative. My comment is mostly on data accountability and responsibility, but aside from the state responsibility, because as we are speaking a lot and giving the state obviously has a very huge responsibility in terms of data protection, but what about a CSO responsibility and individual responsibility to see that data protection is observed? And this is something that Adrian mentioned, that organizations registering with the data protection unit and all this. However, as an individual who comes from Uganda and the queer community, we have seen that there has been misuse of data, not even by the government, by the media itself, by civil society organizations, by other individuals who can be able to access data. In 2009, a list of 200 LGBT people was listed and put on the media. On a national newspaper, harm them, kill them, they have to have children. And this was data that was accessed by an individual and then used by an institution which is not government. So that comes back to asking our questions that do we have data protection policies within our organizations? Do we have data integrity as individuals? Are we accountable? And do the people we collect the data from are aware of what we are going to use this data for? Do we even tell them in that sense? Because we've seen a lot of people collecting data for informing their research project, informing their projects, but they never come back to the people to be accountable to them of what this data has been done. So as we're putting the responsibility on the state, what is our responsibility as individuals, as organizations, and as companies? Thank you.
Thank you so much for who is checking, those who are making so much noise. I like that because it's critical, right? And I think Tanzania, you did mention that you are trained in journalist story. And I'll allow you to start with responding to his question, and then maybe Adrian, you can comment with regards to what Wakesha raised, and then I'll see where we will be with regards to our time here.
So to respond to his question, I'd like to say a bit about what Yemi Forums does. Apart from being a CSO that advocates and promotes civil rights and other things, we also run a Yemi Forum web platform whereby more than 3 million people use the platform. It's a user-generated content platform, and it's one of platform where whistleblowers use to whistleblow a lot of things that concerns the government. And for the past 5 years, Yemi Forums has been in a battle with the government. They wanted us to release personal data of the Yemi Forums users, and we refused because one of our core value is to protect the data of the Jamii Forum's users. So the letter keeps coming to our offices, demanding data, personal data of certain people who whistle-blew some certain stuff in our platform, and we kept on refusing. Our ED was arrested, he was in jail for several months, and they kept on pushing and pushing, demanding for people's data, and we kept on refusing. This was the last regime, the Magufuli regime, and things came back to normal, the Samia regime. But a few weeks ago, we received a letter from the government wanting to know who started a certain thread in our platform about the National Health NHIF. So we answered the letter and we said we won't give you the details of this person because we do not believe in doing so. So we as Jamii Forums, we are very responsible when it comes to people's data. So I hope that at least answer your question is a CSO, what are our responsibilities, and are we accountable to the data that people presents in our platforms? Yeah. Thank you so much.
Yeah, thank you very much. Maybe to just chip in a little bit. As a result of what she's spoken about, the request by the government to release all data of people who are participating. As a result of that, we saw the electronic and postal communications regulations in Tanzania, which of course we did an analysis and shared still together with Jamii Forums. And of course there was also advocacy initiatives to free, what's his name? No, your ED.
Oh,
yeah, Melo. Yeah, so until he was freed, and of course the regulations again came in another dimension again later on, and then also Uganda tried to replicate the same, saying you must, if you have followers, online content creators, when one of the speakers, I think, visited the witch doctor and they never paid, then one of the leading newspapers published an article and said, hey, the Speaker of Parliament went and never paid the man of the witch doctor. So, and then the Speaker raised a concern, and then they summoned the newspaper, Daily Matter, and said, you must take that you do not have a license to provide online content. So, you must pull down this content. Of course, silently, I think the Daily Monitor later pulled down the content, but that was one of them. And then later, some of those, or I should say, all online content providers, maybe on Facebook or YouTube, what must register with the Uganda Communications Commission. As for our very good friends, Internews Wakesho, I want to appreciate you for the recommendations you've given. Really, there was nothing really much for me to react to, but I think we take note of what she has said, making use of those regional institutions. Though, of course, at that level, we've already been working with special rapporteurs, of course. Here and there, some private meetings, sometimes online, and what to provide the information which they usually actually present. But now, like for example, the Pan-African movement, economic and social-cultural, all those, we as CIPESA would not have observer status of the African Commission or even the ECOSOC, but we applied. And for some time, every time we go, they say the application was received and ECOSOC is waiting for review. Then the African Commission, they said, we are working on it, we'll get back to you. But we are still waiting. So, but we continue to ride on the backs of those who have observer status. And for example, take part in the side events where necessary to review such issues that affect our people. Yeah. So, but as civil society, again, one of the things is for them to register and ensure that the data is protected. I think it has been that we usually work hand in hand with the technology authority, that is NITA. We have our contacts there and we talk to them. So people have been registering, even our dear funders and supporters like UNB, for example, were the ones who advised and said, because they were confused about it, said, no, you register. For as long as you hold conferences and people register their names and phone numbers and addresses, then you need to register because you're carrying personal data. So that is ideally it that we do, and we have to, of course, stay positive and ensure that we are on the positive side as opposed to the negative side. We have to be an example since we are pushing for accountability.
Thank you so much, and yes, thank you so much for Kesho. I will also just jump in there and say that I think there's room for more digital rights organizations to plug into these advocacy platforms that you have highlighted. As part of our initiative, we've got observer status with the African Commission just recently, and we have engaged with the African Commission, and we've engaged even with the African Center on Democracy and Human Rights that's ACDHRS, so that we can be able to begin to talk about digital rights at regional level. And I think this year in the next session, we actually managed to get digital rights on the agenda. And if you go on the African Commission website, you see that there's an upcoming 73rd ordinary session. And if you see as well the NGO forum agenda, you see that digital rights is part of that conversation. And part of the work that I actually was doing was to look as well at the website to see how many digital rights actors are actually listed as having observer status. And trust you me, I think there are less than 4 digital rights organizations which are specifically in Africa and specifically driving the work on digital rights. And I think there's room for more digital rights organizations to actually get observer status and also be able to amplify their voices at the African Commission level. I will not speak a lot about other platforms. We've also applied for AU ECOSOC status, and we're hoping also to get a positive feedback. But definitely it's something that we need to plug into, and we take note of the other platforms that you have mentioned as well for engagement at those levels. So thank you so much for being very engaging and very a very good panel and a very good audience. Your parting shots in under a minute. Let's see your ability to summarize and strike. I'll start with you, Nompilo.
Okay, so before I move to my parting shots, since you're already counting, I wanted to respond also to the question that you raised around civil society responsibility and the responsibility of the media, because we also noted that even in Zimbabwe, like during COVID-19, you'd find there were some reports where a media house would report about a person who was identified with COVID-19, and as part of the COVID-19 tracking process, they released some personal identifying information to say this woman tested positive, then party, and the phone numbers of the people that were talking in that group were right there, front page in a newspaper. So definitely there's still a gap in terms of capacitating, the media to really appreciate the principles of data protection and privacy. And yeah, my parting shots really being that, particularly for the Zimbabwean perspective, the law is very clear in terms of the standards, confidentiality, integrity, accessibility, the rights of the data subjects, and so all the principles have been laid out, and we have a responsibility as CSOs to ensure that we monitor compliance with those standards, not only from the government perspective, but from all stakeholders, including ourselves,